If you set up a trust for your house that's paid off to avoid the probate process, but you forget to transfer the property into the revocable trust, it's still going to go through the probate process and your trust is basically useless. The reason being is that when you set up the revocable trust, to put the property inside the revocable trust, you actually have to transfer ownership out of your name into the name of the revocable trust, and now the trust will own that property. You will no longer own it, but you can control it as the trustee of that revocable trust. And so any assets in your name when you pass away will have to go through the probate process. The second layer problem here is how that property gets distributed if you forget to put it inside the revocable trust. It depends on whether or not you have a will. A lot of people set up the revocable trust and think, I don't need to set up a will because I have everything handled already by the revocable trust. But that does not account for any assets you forget to put inside the revocable trust. And so when you pass away those assets in your personal name and they're going through the probate process, they will either be distributed per the intestate laws of your state or per the will that you have set up. As an example, in Georgia, your assets will get split evenly between your spouse and your kids, with your spouse getting a minimum of 1/3 per the intestate laws. And so it's just much easier to set up the revocable trust and actually transfer the assets into there. And so this is such a common occurrence that we actually do an audit at the back end of transferring the assets into the revocable trust, just to make sure that you have actually put all of your assets into that revocable trust correctly.